Losing a loved one is a profoundly difficult experience. Amidst the grief, families often face the daunting task of managing the estate left behind. This legal process, known as probate, can feel overwhelming. Fortunately, the Uniform Probate Code, or UPC, was created to help. The UPC serves as a guide to streamline and standardize the probate process, making it less stressful for grieving families. Before we explore the UPC, please note, this video is for informational purposes only and not legal advice. It is not intended as a substitute for professional legal counsel. When a loved one passes away, you might hear the term probate. But what is it? Probate is the formal court-supervised legal process of administering a deceased person's estate, wrapping up their financial affairs after they are gone. Think of probate as a roadmap with 4 main stops. First is will validation, proving the document is legally binding. Next is asset identification, locating everything the person owned. Then comes debt payment, settling outstanding bills and taxes. Finally, the process ends with asset distribution, transferring the remaining property to the rightful heirs or beneficiaries. Why is this formal procedure necessary? Primarily, it provides the crucial step of clearing title. If a home is left behind, the court legally transfers ownership, so the new owner avoids future legal hurdles. Probate also balances the scales for creditors, providing a strict timeline for them to make valid claims against the estate. Furthermore, the probate court serves as neutral ground for dispute resolution. If family members disagree about the will, a judge is there to settle the conflict fairly. Most importantly, court supervision acts as a protective shield, preventing fraud and ensuring that the deceased person's final wishes are honored exactly as intended. When settling a loved one's estate, the legal process shouldn't add to your burden. Enter the Uniform Probate Code, or UPC. It is not a federal law, but rather a comprehensive set of model laws drafted by the Uniform Law Commission. Individual states can choose to adopt it to govern how estates are handled. The main goal of the UPC is to create a more efficient, less expensive, and user-friendly probate process. When comparing traditional probate to the UPC, the difference is clear. Traditional probate can be complex and painfully slow. The UPC streamlines the system, operating smoothly and removing unnecessary court delays. The code focuses on 5 core objectives: simplifying probate by clearing procedural obstacles, promoting uniformity across state lines, protecting families during a vulnerable time, significantly reducing administrative costs, and offering flexibility with different procedural paths tailored to the estate's needs. Let us look at how the Uniform Probate Code works in practice. The UPC introduces informal probate, a highly streamlined administrative process that bypasses court hearings for uncontested estates, saving significant time and money. But if disputes arise, formal probate steps in, involving court supervision to resolve complex issues. The code also allows for universal succession, a system where heirs can take over an estate without court involvement by assuming both its assets and liabilities. For smaller estates with limited assets, the UPC offers a fast-track affidavit process, allowing heirs to quickly claim what is theirs without a lengthy wait. The UPC goes further to protect families. The elective share provision ensures that a surviving spouse cannot be completely disinherited, guaranteeing them a percentage of the augmented estate based on the length of the marriage. And if someone passes away without a will, the UPC's updated intestacy rules step in, prioritizing the surviving spouse and descendants to reflect modern family structures. These standardized rules aim to simplify the legal labyrinth, ensuring fair and efficient outcomes for grieving families across adopting states. So, how do you know if you live in a UPC state? Several states have adopted all or a significant portion of the Uniform Probate Code. These include Alaska, Arizona, Colorado, Florida, Hawaii, Idaho, Maine, Maryland, Michigan, Minnesota, Montana, Nebraska, New Mexico, North Dakota, South Carolina, South Dakota, and Utah. If your state wasn't mentioned, there are a few simple ways to check its status. You can search your state's statutes online, consult a qualified probate attorney or contact your local probate court directly for guidance. But here is a crucial reminder. Even in states that have adopted the Uniform Probate Code, specific provisions and procedures can still differ. Always verify the local laws that apply to your unique situation to ensure you are following the correct legal steps. The Uniform Probate Code process involves a specific sequence of steps. The journey begins with filing a petition in court. Next is the appointment of a personal representative to manage the estate. Once appointed, they must send official notice to all known heirs and creditors, ensuring everyone is informed of the proceedings. Following the notices, the representative conducts an inventory and appraisal of the assets. After valuing the estate, the next crucial step is paying valid debts and taxes. Only then can the remaining assets be distributed to the beneficiaries. Finally, the representative submits a final accounting, officially closing the estate. How long does this take? Timelines vary. Initial filings might take weeks or months. Creditors typically have 3 to 6 months to file claims. The process might wrap up in 60 to 90 days under informal probate, but complex or contested estates can drag on for months to years. Probate also brings costs, including court, attorney, and appraisal fees. To minimize expenses, proactive estate planning is key. You can also save by opting for informal probate, negotiating your attorney fees up front, and maintaining accurate, organized records to reduce billable hours. Let's debunk a few common probate myths. Myth 1, probate is only for the wealthy. Reality, estates of all sizes go through probate. Myth 2, it is always a long, expensive nightmare. Actually, many states offer streamlined, affordable processes. Myth 3, having a will skips probate. In reality, a will is literally your set of instructions for the probate court. Myth 4, joint ownership completely avoids probate. It works for that specific asset, but individually owned property still needs court approval. So, what are the actual alternatives? First, a living trust lets your assets bypass court entirely. Second, joint ownership with right of survivorship automatically transfers property. Third, payable on death designations on bank accounts send funds directly to beneficiaries. For modest estates, small estate procedures speed things up. Finally, gifting assets while you are alive reduces your estate size, but be sure to consult a professional about tax implications first. Navigating the probate process can feel overwhelming, which is why consulting an experienced attorney is crucial. They will advise you, navigate the paperwork, represent your interests, and minimize disputes. If there is no will, assets follow intestate succession. How long is probate? Typically 6 months to a year. Personal representatives manage the estate, and elective shares protect surviving spouses. Beneficiaries must be formally notified, and if you disagree with a will, an attorney can help you contest it. Ready to take the next step? Visit probateus.com/directory to find your local probate court today. Navigating the Uniform Probate Code does not have to be an overwhelming journey. We hope this guide has brought you clarity. Please like, subscribe, and leave a comment below if you found this helpful. For more support and to find specialized professionals, visit funeralus.com and probateus.com/directory. Thank you for watching and take care.